Well, let's get into our panel discussion for this evening. Two briefings today, one by the Democratic Alliance, another one by the ANC, where the DA has made the point clear that they are still committed to the government of national unity, despite some of the issues that they've raised around consultation and consensus where it comes to policy decisions within this government of national unity. And a briefing by the African National Congress, wherein we heard how the party remains committed to economic justice and transformation. We're in studio this evening with ANC NEC member Phoebe Potgieter. We're joined by DA spokesperson Willie Oukamp, also in studio. Thank you so much for joining us, and a good evening to you.
Good evening.
We really do appreciate it. We're joined by policy analyst as well, Dr. David Mohale, who joins us via video link, as well as political analyst Mr. Sandy Leswana, who listen in to our debate here in studio and perhaps give us a bird's eye view of what they're hearing from you. But thank you so much for joining us. I thought because we'd started the day a little bit earlier with that press briefing by the Democratic Alliance, it would be interesting for us to start off with looking at one of the points that was raised by John Steenhuisen in that briefing, and that being around Section 19 of the Statement of Intent between the parties in the formation of this government of national unity. I want to bring it up for our viewers to look at it and then perhaps debate about how the parties each understand what they see written in front of them. But this is Section 19 that you'll see come up on the screen in just a moment. And of course, remember, we're taking your calls as well on 010-594-6010. That's the number to call, or send us a WhatsApp on 072-110-5584. But Section 19 of the Statement of Intent. Take a look at that. Sufficient consensus exists when all parties have had the opportunity to express their views. Despite reasonable attempts to resolve disagreements and find common ground, there is no general consensus. And then I want to get to 19.3, because this is specifically what John Steenhuisen talked about. Parties to the GNU representing 60% of seats in the National Assembly agree. That is when consensus has been agreed upon according to the Statement of Intent. Willie, do you want to go first, right? You believe that that has not been met, and then there's a question around when that becomes an issue even in government.
Good evening, Naledi. It's nice to be with you. Naledi, I would like to start off by just sending our condolences to the fallen soldiers in the DRC. Our thoughts are with their families, and we pray for them in this difficult time. To get to your question, when the government of national unity was formed, it was very important to get to a point where we know when we will agree as parties to this GNU on something. So when will consensus be there? And obviously, when will it then be sufficient consensus? And to iron out any possible misinterpretations of that, it was agreed that 19.3, and that was included then in the Memorandum of Understanding, that parties to the GNU representing 60% of the votes of the people in the National Assembly. Now, that is a very quick calculation. The only two parties within the GNU that can reach that 60% is the ANC and the DA. No party can reach it alone, because all the parties in the GNU are minority parties. There's no party that reached the 50% plus. The ANC's got 40% and the Democratic Alliance 22%. So the only way in which we can reach that sufficient consensus, at least, is for the ANC and the DA to agree on issues. And that was what was agreed when this Memorandum of Understanding that formed the Government of National Unity was signed between all the parties.
Yeah, and then there's the question, perhaps you can step in here, Phoebe, about your understanding from the ANC's point of view around that particular part of the Statement of Intent. And if even prior to this very agreement of the Statement of Intent amongst the parties, you can't say between, because it's more than two, certainly. But even in that agreement, was policy not discussed prior? So talk to me about your interpretation.
The Statement of Intent must be seen in its entirety. So it's divided into different sections. So the first section speak about foundational principles, which are the policy matters. Then it look at what are regarded as the minimum program of the 7th administration, which then delved into what do we see as priorities. And then the third issue deals with, operational matters about conflict resolution, the a mechanism for consultation, and so forth. Now, one of the principles of the foundational principles is the rule of law and the Constitution, which nobody has any disagreement with that. And the reality is that the laws that the DA is talking about are laws that was adopted by Parliament in the sixth administration, passed by Parliament through its regular processes. It was then sent to the President, as is the process that needs to be followed with laws. The President then had to sign it, whether it's before or after elections. And part of the reason for some of the delays with the laws that he had to pass, that were passed in the sixth administration, was because he had to check whether they're constitutional, whether they're in line with the Constitution and other prescripts, and as well as the processes that were followed. So the DA, during the negotiations, didn't read that it wanted to change laws or any policies adopted by the sixth administration. There was agreement on the foundational principles. There was agreement about the minimum program, and there was agreement about within the seventh administration how we will resolve conflict. Now, when a law goes through a process, so whether it's a private member's bill or whether it's a bill from the executive, it goes to Parliament, it goes to the NCOP, and then it comes to the President to then sign it and give effect to it in law. Now, that's a process that's prescribed in the Constitution and in law. The seventh administration, if there are laws that needs to be passed, it will have to go through that process as well. Cabinet, and in this case, the Government of National Unity Cabinet, will have to look at that law and then say, we don't agree with it, we refer to the clearinghouse because there's disagreement between some of the parties about it, and then try to find a consensus there. But you can't want to retrospectively address a process that was followed by a duly elected Parliament during the sixth administration. What the DA can do is to come to Cabinet and say, we want amendments to this law in order to repeal it in total or to amend certain sections that we're not happy with. But you can't. It's against the rule of law that a Parliament that has been elected, that's the sixth administration Parliament, you then want to now come and say that we want to pick and choose which ones of a duly elected sixth Parliament of the laws do we want to implement or not, and we don't think that's right.
Yeah, what's interesting is that really, where implementation is concerned, it's hard to ignore the fact that where the Bella Act is concerned, you've got a DA minister who's got to implement. Infrastructure, you've got a DA minister to implement. You've got a DA minister who is also leader of the Democratic Alliance. As Minister of Agriculture, who's got to support the programs that come from the Expropriation Act. And so I wonder what that does for the Democratic Alliance and what we heard today from the party saying you're preparing yourselves for campaigning in 2026. When you certainly have one messaging that you give to your electorate, but you have very prominent members of the party that have to implement some of these policies.
Naledi, all our ministers took an oath of office where they swore that they will uphold the constitution of this country. In both these legislations, Bella, as well as the Expropriation Act, the ministers wrote to the president and advised him on the constitutionality issues that were present in those bills. Let's take Minister Dean McPherson, the Minister of Public Works and Infrastructure. He obtained a legal opinion from some of the best constitutional legal minds in this country, which clearly put out what clauses in the bill there was constitutionality problems with. He then advised the president on that. The president unfortunately chose to ignore him. It is the job of a minister to advise the president. The fact is that the minister did not swear allegiance to the president. He swore to uphold the constitution. Now, Phoebe is right. We could have brought amendments and told the Government of National Unity, we want amendments to these bills. But Phoebe, that's exactly what we did. We said to the GNU, we want certain clauses in the Bella Act.
That's not quite
as
what
well
I said.
Let me just finish.
I'll give you an opportunity.
The point is that we can bring amendments to the GNU, and that is exactly what we've done. With the Bella Act, as well as with the Expropriation Act, the DA came to the GNU and said, please don't sign it in its current format. We need to negotiate it. We want this to be changed. And apart from that, as I said previously, our ministers also advise the president on the constitutionality thereof. The president can always send something back when there is doubt of constitutionality. He can either approach the Constitutional Court himself and ask the Constitutional Court to speak out and give an opinion about the constitutionality, or he can send it back to the National Assembly and say, I've got problems with clause A, B, and C, have a look at it so that it can be changed in order for it to meet constitutional muster. He did not do that.
Okay, do you want to go ahead?
Yeah. What I said is that the DA has the right to put an amendment bill. The Bella Act, the Expropriation Act, the NHI Act have been passed by Parliament after an extensive process.
Right.
It went to the NCOP. It was passed by Parliament. That's what Parliament does, and then it refers it to the President.
Yeah.
In a similar vein, the President sought constitutional lawyers' advice about the constitutionality of all of these laws. And the final arbiter of whether these laws are constitutional or not will be the Constitutional Court. The DA and other parties that are not happy with a particular piece of legislation or aspect of it have the right in our constitutional democracy to take it to the Constitutional Court. But the issue is you can't, as a seventh administration, without going through the proper processes, then say that you want to not accept what was done by the sixth administration when the legal process and constitutional process was followed.
Let's get some outside voices in here, because otherwise we could go back and forth for a while. David Mohale, Dr. David Mohale, policy analyst. Really interesting to have you with us. You listened to the DA and the ANC this evening, and I wonder if you hear here a debate about policy, procedure, or politics.
Thank you very much, Naledi, for having me. Good evening to you, to the panelists, and to the viewers at home. Look, on the surface of it, this is a complex matter of interface between politics and policy, obviously, with political parties being the source of the policy input in government. But based on the DA's argument, to be in all fairness, one is struggling to hear a very strong argument that they can put against. Well, Phoebe has spoken to this already, but when you read Chapter 5 of the Constitution, which is basically about the executive, the president, the cabinet, powers and functions, out of about 13 or so powers and functions, the first, actually, the Constitution lists that the president has to assent to bills. And the president assent to bills, as Phoebe was saying, having followed a particular process. And indeed, the Constitution goes further to list two conditions on which the president may not assent to bills. One, if the president is not convinced regarding the constitutionality of the bill, or he would like the parliament to make certain considerations regarding the bill itself. And I've not heard the DA arguing that in terms of the process, the president should not have signed it because we believe there was a loophole regarding this or that. I don't think what is important is to appreciate that, like in any other organization or entity, government operates in continuity. The fact that this process is, ideally this should have been concluded in the previous administration, but the fact that they were not concluded, but the parliament had concluded its own processes, does not therefore that the president could ignore. And yes, indeed, what is the avenue that the DA does have in this instance if they feel aggrieved? In terms of where the process is, the only avenue they do have is a recourse to Constitutional Court. It's one thing to argue that the ministers sought legal opinion, but legal opinion, even you could have the best brain available. It remains an opinion, and that's what they are telling the public. We do not know whether the president would have received opinion or not. What we do know is that there is state law advisors. I cannot imagine a situation where the president would assent to any legislation without having sought legal opinion himself. So what you do then when you have got more than one opinions that are contradictory, you have got to trust that your decision is correct, and in an event that there are gaps on constitutionality, then the Constitutional Court becomes the final arbiter.
Yeah, you know, Mr. Swana, I'm going to bring you in here as a political analyst, because again, the question I asked to Dr. Mohale is, are we talking Is this a debate about policy process or policy or politics? I mean, hard to ignore the fact that 2026 is an election year, and you've got parties that need to speak directly to their constituents and stick to, I suppose, their policy proposals for what they've always said to their electorate. But now they've got to work together and find middle ground somehow. So, I mean, what are you hearing from the two parties that we've got in studio with us this evening?
Yes, thank you, Naledi. There is a very strong political flavor in my judgment, because I do not see any other avenue for the DA to proceed other than to go to the Constitutional Court. Otherwise, they've got to propose amendments. Now, on the political front, the parties that are in studio today really and truly need to explain to South Africans what is going on. I say this because I detect a lack of political will to do the right thing. F.W. de Klerk, a leader of the apartheid government in the white minority regime, in 1990 unbanned the African National Congress. On the 30th of June, as I recall, June 1991, he promulgated the Abolition of Racially Based Land Measures Act 108 of 1991, which basically released South Africans, not the non-European South Africans, to say, look, you can now participate in the land market or the land procedures of the country without the Land Act and all these other, I mean, scholars say there's about 51 land-related acts that are were racially based in South Africa. So de Klerk in 1990 unbans the African nation. The very following year, he actually abolishes every law that prevents a black person from owning land anywhere in South Africa. The ANC and the DA, in whatever configuration you want to talk about, in 1996, they launched the Constitution. If they were thinking like de Klerk, the following year they would have passed this act. More importantly, the philosophies and the beliefs that all South Africans must now participate fully in land ownership across South Africa, and anything that represents racism in the ownership of land in South Africa must be totally erased, could have been done already in 1997. Okay. It could have been done.
Yeah, okay.
So what is the question? What are they waiting for? Why are they dilly-dallying like this now?
Okay, yeah, thanks for that. We're going to take calls on this discussion as well. Feel free to give us a call on 0105946010. Yandisa is on the line in Pretoria. Yandisa, good evening.
Good evening, Newzroom Afrika.
Yes, talk to us.
Yes, what I want to say, why all along the president was doing, because this thing is not a new, and now the GNU, he decided to sign it. There was agreement there was agreement between GNU parties. Another question, why is only DA who has a problem now to this land exploration? That's my question.
Okay, but the DA is not the only party. The EFF has come out and said that they don't think that the act in itself goes as far as it should. The Patriotic Alliance has also been quite outspoken, Yandisa.
Yes, EFF is not there. I think, if I'm not mistaken, it's
sure, 100%. Yes, I'm just talking about other parties that have spoken out. Yes.
I didn't hear them. I always DA. That's why. And another thing, the president is wrong by not consulting. If he did it, all of the GNU parties, and they should have agreed. They have an agreement. I don't know why those have a problem with it, because I think there is an agreement there.
All right, Yandisa.
The DA must tell us what was the agreement on this land exploration.
Okay, yeah, we're gonna hear an answer to that on the other side of this. Yandisa, calling from Pretoria. We're taking more calls on 010-594-6010. Let's take a short break. We're going to continue in a moment. Welcome back. We continue our panel discussion on the state of the government of national unity, and certainly what seems to be a policy impasse between certainly the ANC and the Democratic Alliance, but concerns also being raised by other political parties on the signing of the Expropriation Bill. And we continue with our panelists, but we're taking calls as well. We have Seka in Alberton. Seka, good evening.
Good evening, madam. How are you?
I'm well, sir. Talk to us. What are your thoughts?
Yeah, my thought is actually I'm failing to understand here. Before the bill sent to the president, the sixth administration followed Section 76 of the Constitution, 76(1), all the processes, legal and constitutional processes of the Constitution. And the DA was the opposition party by then. I've never had the DA having a concern when this bill was sent to the president, because this was discussed, and the sixth administration made sure that they reached the requirement in terms of voting, because before a bill is sent to the president, they must reach voting. It must secure a two-thirds majority to pass that bill. Now, the DA wants us to believe, to tell us or to convince us that their lawyers were the best lawyers in the world, versus the consensus, the legal consensus or legal opinion that the president was waiting, was consulting before you could pass this bill. The DA undermining the country. We are sticking to the Constitution. They actually want to change the Constitution, of which they are following the wrong procedure. The woman of the ANC, she's correct. If the DA wants to change something in the Constitution, let them follow correct procedures, unlike hijacking. So the GNU cannot supersede the Constitution.
Okay. All right. Yeah. Seka, thank you so much. Ntombi is in Johannesburg. Ntombi, good evening.
Good evening, ma'am. How are you?
I'm well. Thank you for calling.
Thank you. Thank you for having me. I would just like to comment, Mr. President has made a mistake. He is not alone. ANC is not alone in the GNU. So he's supposed to sit down with the ministers, and discuss this before. So they are no longer in power now. I think they have to sit down and discuss whatsoever, even if it's not only this bill.
Yeah, okay. Ntombi, thank you so much for that. I want to actually bring something up on the screen, and this goes back to that statement of intent that we talked about. Section 20 that talks about dispute resolution. It reads, the parties to the GNU shall establish dispute resolution or deadlock breaking mechanisms. In instances where sufficient consensus is not reached, parties should raise disputes within the mechanisms created for this purpose. And then we saw the clearinghouse. But Willie, I'll come back to you. Today we heard John Steenhuisen say if there's persistence on passing things through, as you say, with insufficient consistency. He uses the word, it will not be tolerated. One wonders what that means, right? It will not be tolerated. Then what next? Exit the government of national unity? So is there a condition that is sitting for the Democratic Alliance that says, all right, at this particular point, we're no longer part of this government?
Naledi, when we came into this government, we said that we are here to grow the economy and create jobs. That should be the two primary objectives of this GNU. And the moment that we see that we can't make a difference and that we can't implement that anymore, will be the day that we will reconsider our position within the GNU. Excuse me. I think it's very important for this GNU to work that all parties to the GNU comes to the table with a clear objective. But all parties to this GNU, and especially the ANC, must now realize that they don't govern alone. The ANC got used to over 30 years of having a majority. But that majority was taken away. The people of South Africa decided that they do not trust the ANC to govern alone anymore, and that is why they only received a little bit less than 40, but let's say 40% in the elections. 22% of the people voted for the DA. We are the two biggest parties, and there are various other parties in this GNU. For this GNU to work, parties need to respect each other. I want to come back to what your panelists said, and I want to just reiterate again that the Democratic Alliance, in these bills that has been passed, has proposed amendments. In the GNU, you don't want to have the only resolution with one of your partners to go to court every time. You would like to sort out problems before you have to approach the Constitutional Court. It would have been much nicer for us, as a partner of the ANC in this government of national unity, if we could have discussed the problems that we had with the Expropriation Bill, sat down and say, these are the problems, these are the constitutionality issues, how can we sort that out? Instead of now ex post facto have to approach the courts to do that. It's nicer not to fight with your partners. And I think that is very important as well. To come back to the legal opinions, one of the callers spoke about that. The legal opinion that Minister McPherson obtained wasn't a DA legal opinion. That legal opinion was obtained on behalf of the Department of Public Works and Infrastructure. So it is his job to advise the president, which he did. Unfortunately, we are at a stage where the president did not listen. And I think that is the importance of the conversation that our leader, John Steenhuisen, tonight is having with the president. I think they're meeting at 9 o'clock tonight. Yeah. So I think they're sitting and watching you and me, Phoebe, and see how we sort it out and hopefully implement it there. So they are having this meeting tonight. And John Steenhuisen made it very clear that the Democratic Alliance will not be co-opted in this GNU to just rubber stamp through ANC policies. It's one thing for the president to stand on the international stage in Davos and other places and brag about this GNU, the accomplishments of this GNU. But back at home, he only steamrolled through old ANC policies. If we look, Naledi, at what the markets did over the last 24 hours, when we had our press briefing on Saturday and announced that we are invoking clause 19.3, the rand dipped. Today, when we had our meeting, our press briefing, and we spoke and said that John Steenhuisen will meet the president, and John Steenhuisen made it clear today that we are committed to this GNU, and we will do everything in our power to save this GNU. All of a sudden, the rand strengthened, and I read about articles of several financial gurus in South Africa that attributed that to the instability that was created and hopefully stability that can come out of this conversation between John Steenhuisen and the president. The main thing is just that partners should respect each other, and we must not come with an arrogant attitude towards the negotiations. All things that's going to happen in this GNU will be negotiations.
Yeah,
Yeah,
sure. Go ahead, because I think we've heard the word arrogant quite a lot lately, and I'm really keen to hear your thoughts on that. The rand dips, the rand doesn't dip. Yeah. Can the ANC afford to lose this partner of GNU?
Well, I think that let me go a step back to say that the laws that we're talking about were passed by the Sixth Administration through a majority. It went through the proper process, and we can't now, in a subsequent administration, wanting to say that that process is thrown out through deal-making, through the back door. The proper procedure must be followed. The president, through his state law advisors, sought legal opinion around the constitutionality of every bill that he cites.
Yeah.
There may be a different opinion, as there was on Bala and on, I'm sure, a number of other transformation legislation, but the reality is that the proper procedure was followed in the Sixth Administration. With regards to the Seventh Administration, which is the basis on which we got the 40%, on which the GNU was formed, there is a commitment towards consultation on those issues. When the president, before he did his opening of Parliament address, there was a cabinet lekgotla of the entire GNU cabinet that looked at what should go into that opening of Parliament address, the three priorities that the president put forward. None of the parties disagree with that. So to come here now and say that there isn't consultation on matters of the 7th administration, I think it's a bit disingenuous, and I think it's against the foundational principles of the statement of intent, which says that we will follow the rule of law.
Okay.
And part of what the rule of law say, there's a certain procedure with following the laws. The president has a specific role once Parliament passes laws, and he has the responsibility to fulfill those responsibilities.
Right.
Of course, if there is a law that arises in from a minister in the 7th administration, it will have to go through the proper process. It will have to be submitted to cabinet. If there's no agreement in cabinet, it can then be referred to in line with clause 19 to the clearinghouse to find consensus. And then attempts to find consensus around those issues.
So I think we've touched on the issue of process, and I want to focus on the politics a little bit, because I want to, go back to the tone that we heard from even both parties today. But if we
respond to your question about the rand.
100%, yes, the rand. So John Steenhuisen says we're invoking 19.3. The rand dips, the rand comes, strengthens when.
But that's also highly problematic, because both of them has got to do with the DA. So you say you're not going to do X, and then you say you're going to do Y, and the rand respond to that. During the negotiations, for example, and afterwards the DA admitted through your negotiating team that they used it as a negotiating tool to be able to release information to the financial markets, and then it dips, and we're supposed to get scared. The reality is that South Africa, 30 years after democracy, and let me use the expropriation of land as an example. And I think that the panelist is very correct. It's something that we should have done in the early 90s. But the reality was we were finding our feet in a very conflictual situation where land was a really difficult issue. But in the Constitution provided a framework. Over the last 10 years, we've attempted, certainly as the ANC, to amend Section 25 of the Constitution. We didn't get the support because we needed 2/3 to do that. We didn't go back and try and get it through the back door. We went the route that the Constitution then provided for, and it says that legislation must be provided to allow for expropriation. And that's the route that we followed. But I think that the in a government of national unity, there are conflicting political positions and constituencies and so forth, and we accept that. And this is why the commitment from certainly the president is, and the ANC, the creation of the clearinghouse, the fact that you have a cabinet where people have the ability to discuss matters, to process matters, and if they can't agree, there's a clearinghouse. But to want to undo in an unconstitutional way what was done by a duly elected parliament, which was the 6th parliament,
right, okay.
I don't think that is right.
Yeah, can I bring in my panelists once again? Mr. Sandile Swana, I want to bring you back in here because, again, I go back to the tone of what we heard from the political parties today. If the ANC persists, it will not be tolerated. Not necessarily using the words that we will... No, that was the words of John Steenhuisen this afternoon, yes. And as he says that in that press briefing, not necessarily saying that we could walk away from this government of national unity, but it does beg the question, either party and also the country, but I'm keen to hear on either party whether they can afford to walk away from the government of national unity.
The DA and the African National Congress, the two parties, none of them is going to walk away from the GNU as we've come to know it. And there's another party that is not mentioned, which is an owner, a part owner of this GNU, which is BLSA, BUSA, and Business for South Africa before SA, which demanded on the 28th of May 2024 that this coalition must be formed in the manner that it is. So the DA and the ANC have got their boss in big business, and they are going to stay there. Okay. So it's an empty threat, it's a dead snake. The threat about the rand, the value of the rand, is used for people who don't know economics. It has nothing to do with this. absolutely zero to do. Investors are long-term investors. The people who can shake the currency, and we know who they are short-term speculators. They are not investors. And we know who the actual investors, proper investors of South Africa are. They are not affected by that, and their interests are protected and safe. There is no threat to long-term investors in South Africa right now, not even by Steenhuisen or anybody. Lastly, unfortunately, in this discussion, the DA has not disclosed this true political intention. The ANC says they had a hostile environment when they wanted to do this act or to change the constitution or to proceed with this expropriation of land. In fact, land redistribution from the white minority to the black majority. They had difficulties with that. And this whole meeting that we're having tonight is about the DA stopping the ANC and everybody else from starting the process which is necessary and beneficial to South Africa economically to actually distribute land from the white minority to the black majority so that there is economic justice in South Africa and economic growth such as was seen in the Asian tigers. Land redistribution was used as an accelerator of economic growth among the Asian tigers. The DA has not been honest and did not make a full disclosure. Why? What is their political object? We're discussing procedures which they do not comply with themselves. They are wanting a veto. And what are they vetoing? The actual redistribution of land by the state from the white minority to the black majority. That is what this discussion is all about. And that has not been discussed so far.
Just a second. I need to just bring some and one more voice in. Dr. Mohale, you hear Sandile Swana saying, none of these parties are going to walk away from the government of national unity. That's the position that that's put forward by Swana. What does that mean then for the enactment of the very acts that have been contentious between the two parties? So by that I mean where there are opportunities for the battle then to be taken forward even in the enactment. Some legal pundits saying, well, a minister can in fact start to put in place regulations to make it difficult, for instance, for expropriation to take place. What do you see there?
Well, that is one option, but remember that I referred to the entirety of Chapter 5 of the Constitution so that it is read and understood in context, because one of the provisions in the chapter does speak to the fact that the president also has inherent powers, by the way, to can assign powers and functions of a city minister to somebody else, should he come to the realization that perhaps there's justification for that. So as much as the DA guest in studio is saying that their members saw allegiance to the Constitution, that is correct. The Constitution also empowers the president to take certain decisions. And I do not, as much, and I think Sandile is correct, political arrangement should not be confused with policy matters. At the end of the day, the country needs to run, and the executive authority of the country in terms of the Constitution is vested in the president, working together with members of cabinet. So whatever powers that the minister may have, those powers are not inherent. They are delegated by the president, and the president can at any point in time, perhaps these are the issues which may be on the table of the parties to GNU in terms of what would then mean a sufficient consensus for a president to remove one minister or another or take functions and assign them elsewhere. But bottom line is that these are the acts that were ideally should have been concluded in the 6th administration. For anybody to come at a later stage and opportunistically wants to stop the process that was not legally found wanting, it's opportunistic. And perhaps the last point, and I don't think Sandile is correct, obviously at ideological level, many of us were always skeptical about the authentic commitment of all parties in the GNU, particularly the statement of the intent at its preamble speaks about the importance of acknowledging the preamble of the Constitution, amongst others, which speaks about redress. And it will be interesting to find out how DA would want these historical injustices to be addressed if it fundamentally does not see anything wrong with the current skewed development and economic exchange.
All right, Dr. Mohale, thank you. You know, I know that this is a very emotive discussion. We all have a lot to say. In fact, we've got some WhatsApps as well. But I need to take a quick break. We're going to read those WhatsApps, and then we'll hear from our guests in studio in just a few moments. We are expecting President Cyril Ramaphosa of the African National Congress and certainly John Steenhuisen of the Democratic Alliance to be meeting. Perhaps a little message to them on really what needs to be taking place in that discussion before that cabinet lekgotla this week. We're back in a moment. Welcome back. We continue our discussion just moments before the two leaders of the two biggest parties in the Government of National Unity, the ANC and the Democratic Alliance, meet to discuss an impasse ahead of the cabinet lekgotla set to take place this week. We're taking your WhatsApps on this discussion. 072-110-5584 is the number if you'd like to send us a text message. We talk about text messages all the time. You're more than welcome to send a video as well. We'd love to see your face. Mlungisi Jobeka says, did the DA miss the opportunity to participate in the extensive consultation processes regarding these legislations? Mlungisi, thank you for sending in that WhatsApp. Let's get another one. Ngoskona. Manana in Ladysmith says the GNU will implement the recent bill on expropriation as signed by the president, and there's no meeting with Minister Steenhuisen that will change that. Okay, Goskona, thanks for that message. Apostle Lakim Goni says, hey, Naledi cracks starting during the formation of the GNU, the drafting of the statement of intent to DA, Freedom Front Plus and others masqueraded as progressive parties. They didn't want the poor masses of the country to benefit. I'm going to assume that FFP is Freedom Front Plus. Temba Marabe says the cracks in the GNU were bound to happen, hence the ANC must stand firm on policies and principles to emancipate the marginalized in the country. Temba, thank you so much for that WhatsApp. We've got Sisa in Durban on the line. Sisa, good evening.
Good evening to you and the listeners of the Newzroom Afrika.
Appreciate it. What are your thoughts?
Yeah, my thoughts are as follows. I want to be very simple and straightforward.
Sure.
I want to cut across a few issues that I think are very critical for the South Africans and for the political parties that are actually participating in making our government, effective and functional. One, first and foremost, I think DA needs to come to realization and swallow their pride and go back to the stance wherein they said in one of their founding manifestos or some of the statements that they are the only nation that can build a united South Africa. So if they are still claiming that particular statement, I think they must now appreciate the steps that government is trying to put forth in ensuring that all South Africans partake into the riches of this country.
Yeah.
First and foremost, land is very critical. So let me get to, for instance, an expropriation bill without compensation. In terms of constitution, when you look at similarities, look at constitution, look at the expropriation bill, you would find that land reform, these documents are both dealing with the aim of addressing historical injustices and inequalities, and especially regarding the land dispossession by the apartheid and the colonial system. So I don't think DA should have a problem. Two, in terms of constitutional mandate, expropriation bill aligns with Section 25, wherein you would be looking at constitution in terms of what it wants to do, where expropriation in terms of the public interest. That's what this bill has to achieve as well.
Okay.
So when you look at the compensation framework, you would realize that both these documents, which is they recognize the compensation that must be just and equitable, taking into account factors such as market value related and the historical injustices. So again, the aim must swallow their pride and understand that this is a government of the national unity.
All right.
And this is a government that must govern the people of South Africa, bring them together as a rainbow nation. In other words, they always. I was in one of in the conference.
Okay, I need to let you wrap there, Sisa, because I'm running out of time. But I think your point certainly has been made. Thank you so much for calling in. Let's get final thoughts in here. Villa, you wanted to speak, and just as you respond to what you've heard from the panelists, I think it was Sandile that you wanted to respond to. I'm also keen to hear this. Let's assume that the President and John Steenhuisen are watching this discussion, perhaps in preparation for their discussion at 9 o'clock. What's the ideal outcome coming out of that discussion, say at 10, for instance?
Well, I would hope that the ideal outcome would be that all the parties start to listen to each other. Now, Lady, I just quickly want to come back to a few things. There was a lot of things that were discussed. Phoebe said that the Democratic Alliance is using the markets as a negotiating tool. It is not the DA that is using that. It is the markets. It's the markets that clearly shows the ANC that they want to be listened to. If the ANC is marginalizing the DA within the GNU, the markets react because they know the DA brings a stabilizing factor. I want to answer on Sandile's accusation of the DA wanting to protect whites when it comes to land. Please, Sandile, go to the Western Cape, where the DA has been governing, and go and compare the land reform and redistribution of land in the Western Cape to all 8 other provinces in the country. The Western Cape outperformed all 8 other provinces when it came to land redistribution because we did it in the right way. If you look at the old high-level panel under former President Kgalema Motlanthe, it said that it was not the constitution that stands in the way of land reform, but it was corrupt actions within the ANC government that stands in the place of land reform. The Democratic Alliance is fully in favor of land reform. But if you look at this bill, or this act now, this act, to give you one example, Naledi, says that there must be negotiations between government and a landowner or a property owner. And the moment that those negotiations doesn't bear any fruit, then government can come and they can expropriate the land without compensation. So what in effect does it mean? It means that any landowner that goes into negotiations with the government does so with a gun against his head. Because if I am not going to agree to whatever the amount is that government offers me, they can then go and expropriate my land without compensation. Now, just as we must in this GNU have respect for each other when it comes to negotiating and speaking to each other, you must also respect any property owner that government enters into negotiations with. And that is the effect, because that is what the law says.
Okay, so, I need to step in, and also final thoughts from you. Is there a possibility that any discussion that takes place between the two leaders could see the president backtracking in any way?
I think it's unlikely. Because the question about the expropriation of land bill is provided for in the Constitution. It's long overdue. It's 30 years later. And I think that the issues raised, I mean, take, for example, the large amount of land claims that's still outstanding. And part of the reason, apart from the fact that the judiciary didn't have a capacity and there's now full-time judges appointed to the land claims court, has also got to do with the fact that you had long negotiations with say, for example, my family has lost due to the Group Areas Act. I've proven my claim, but you have to have negotiations with the owner, the current owner, about the price, and usually it's exorbitant, etc., etc. And that has delayed a lot of the claims across the country. Now, the Land Expropriation Bill addressed that. There's also circumstances where it provides for in the public good. So, for example, if we need to build a railway line or expand a highway, it provides for expropriation in the public interest. It also provides for expropriation in circumstances where it's for environmental reasons. Say homes are built on top of a dolomite area. So there's a whole range of that, but fundamentally to it is the question of addressing the historical injustice. And this is why I think that the president, when he signed the bill, did so consciously of the fact that that constitution that he negotiated in 1996 talk about historical redress, and in fact it's part of the foundational principles of the statement of intent.
Yeah, I wish we had more time, because this is a debate that can keep going, but I suppose it will be continued by the president, yes, as well as John Steenhuisen. Dr. Mohale, I'm going to let you have the last bite here, and I've got about maybe a minute and a half for you and a minute and a half for you, Mr. Swana. Closing thoughts. Dr. Mohale, let's assume that John Steenhuisen and the president are listening. Your recommendations going into this discussion?
Look, it is in the interest of the country that you have a cohesive cabinet that gets to communicate with one message. I do think that over and above everything else, besides fair, justifiable political differences, when it comes to governance, all parties need to come across as being committed to one thing and one thing only, which is the 3 priorities which have been agreed to. And it is important that all parties speak with one voice. One would advise that whoever is the minister does not belong to the ANC, and they get aggrieved by this or that. I don't think it could only be fair if such differences are ironed out in the background. It is not in the interest of a kind of cabinet that we require as citizens, at least from citizen point of view, to have members of cabinet arguing about policy matters in public. It doesn't inspire confidence, I think.
Okay.
So that will be the advice that I would give.
All right. Mr. Swana, your advice to the two leaders?
The DA and the ANC, but we will talk about the DA for now, is that the GNU must not be an issue of vetoing South Africans. You lose a matter in Parliament and you come and veto it in the GNU. We've seen adverts from the DA today showing that they've been kicked out of municipalities by the Freedom Front Plus because they are arrogant and very stubborn. My prediction initially was that this GNU was not going to last because of the bully boy tactics of the DA and the bully boy tactics of the ANC. But thankfully, BUSA, BLSA, and B4SA have been the glue that have held them together. I think investors must be very confident. We're proceeding nicely, no problem.
Okay, we're going to leave it there. I know that you want to respond.
I would have loved to respond to that. But
I know. Okay, I'll let you have 30 seconds. Go ahead.
As investors will run away from this country due to this expropriations bill, the parties that Sandile talked about there now, their donors have already ran away due to them doing what they've done. The parties that he is trying to clearly, subjectively try to promote tonight, collectively doesn't even have 3% in this country. So let's stick with what we are doing. We are in this GNU because we wanted to make a difference. Those parties didn't even want to enter the GNU. The Democratic Alliance is here. We are willing to work with the ANC and all our partners in this GNU to better this country and better the lives of every South African, and we are committed to that process.
Yeah. Can I say that I don't agree with the speaker's point that the glue that holds the GNU together and its accountability is to the organizations that he mentioned, mainly business. Because the 40% of people that voted for us are mainly working class poor. It's not BUSA and those ones that voted for it. In fact, they voted for my colleague here. So I think that what for us, the glue that holds together and which will force us during this on 7th administration issues and the 3 priorities which the President announced to work together on that is the commitment towards the electorate, towards the majority of South African citizens who voted for all our parties, who are part of the government of national unity. And that, at the end of the day, is the constituency that should make sure that who we serve, but also whose interests must be paramount.
I'm going to suggest that we let the two leaders of the party take the debate further. And I've really appreciated your time. Thank you so much for speaking to us via video link. Sandile Swana, political analyst, Dr. David Mohale, a policy expert there. Vili Okamp is, of course, the spokesperson for the Democratic Alliance, and Ms. Phoebe Botrita Kobule, who is, of course, ANC NEC member in studio with us. And we've enjoyed some of your interactions. Keep the WhatsApps coming in, though, 721105584.